You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand dictation number 417 and the dictation speed is 120 words per minute. Ready? Start. The Protection of Women from Domestic Violence Act 2005 is one of the first in this sphere. This act has concretely dealt with the problem of domestic violence, taking into consideration all the related laws and has attempted to reduce the numerous ancillary problems generally faced by such legislations. This legislation is well placed in the Indian context and social scenario, clearly reflective of the mindset of the Indian men. This commentary primarily looks into the provisions of this act from the constitutional perspective, the fundamental rights to be particular. The main aim of the commentary is to bring to light the numerous rights, most of which are constitutionally guaranteed, of women who are protected directly or indirectly by this act. The all encompassing nature of the legislation is elucidated among the other positive aspects of this law. The Act is thus a very vital piece of legislation from the feminist perspective of law. However, one of the main and primary criticisms of the writers is that this act intentionally or unintentionally neglects to address the issue of child abuse among male children. This persisting problem, having been left without any such specific laws, requires quick and immediate addressal. Domestic violence is sadly a reality in Indian society. In the Indian patriarchal setup, it became an acceptable practice to abuse women. There may be many reasons for the occurrence of domestic violence. From a feminist standpoint, it could be said that the occurrence of domestic violence against women arises out of the patriarchal setup, the stereotyping of gender roles, and the distribution of power, real or perceived, in society. Following such ideology, men are believed to be stronger than women and more powerful. They control women and their lives, and as a result of this power play, they may hurt women with impunity. The role of the woman is to accept her fate and the violence employed against her meekly. The Protection of Women from Domestic Violence Act is a laudable piece of legislation that was enacted in 2005 to tackle this problem. The act, in theory, goes a long way towards protection of women in the domestic setup. It is the first substantial step in the direction of defeating the questionable public/private distinction traditionally maintained in the law, which has been challenged by feminists time and again. Admittedly, women could earlier approach the courts under the Indian Penal Code in cases of domestic violence. However, the kinds of domestic violence contemplated by this act and the victims recognized by it make it more expansive in scope than the IPC. The IPC never used the term domestic violence to refer to this objectionable practice. In fact, the only similar class of offenses addressed by the IPC dealt with cruelty to married women. All other instances of domestic violence within the household had to be dealt with under the offenses that the respective acts of violence constituted under the IPC without any regard to the gender of the victim. This posed a problem, especially where the victims were children or women who were dependent on the assailant. In fact, even where the victim was the wife of the assailant and could approach the courts under Section 498A of the IPC, she would presumably have to move out of her matrimonial home to ensure her safety or face further violence as retaliation. There was no measure in place to allow her to continue staying in her matrimonial home and yet raise her voice against the violence perpetrated against her. This, together with many other problems faced by women in the household, prompted this enactment. This commentary focuses on the constitutional perspectives of this progressive legislation. The Act, in a bold break from prior legislations, gives a very expansive definition to the term domestic violence, a term hitherto not even used in legal parlance. Domestic violence is defined in a comprehensive way in Section 3 of the Act, comprising physical, mental, verbal, emotional, sexual, and economic abuse, harassment for dowry, acts of threatening to abuse the victim or any other person related to her. The Act thus deals with forms of abuse that were either not addressed earlier or that were addressed in ways not as broad as done here. For instance, it includes in its ambit sexual abuse like marital rape, which, though excluded under the IPC, can now be legally recognized as a form of abuse under the definition of sexual abuse in this Act. The definition also encompasses claims for compensation arising out of domestic violence and includes maintenance similar to that provided for under Section 125 of the Code of Criminal Procedure. Nevertheless, the claim for compensation is not limited to maintenance as allowed by that provision. It is noteworthy that the maintenance available under this section must be in correspondence with the lifestyle of the aggrieved party. Lastly, the Act identifies emotional abuse as a form of domestic violence, including insults on account of the victims not having any children or male children. The enactment in question was passed by the Parliament with recourse to Article 253 of the Constitution. This provision confers on the Parliament the power to make laws in pursuance of international treaties, conventions, etc. The Domestic Violence Act, passed in furtherance of the recommendations of the United Nations Committee on the CEDAW. The Act encompasses all the provisions of the specific recommendations which form a part of General Recommendation number 19 of 1992. The Statement of Objects and Reasons declares that the Act was being passed keeping in view the fundamental rights guaranteed under Articles 14, 15, and 21. Article 21 confers the right to life and liberty in negative terms, stating that it may not be taken away except by procedure established by law, which is required as a result of judicial decisions to be fair, just, and reasonable. The right to life has been held to include the right to be free of violence, the right to dignity, and the right to shelter. Article 14 contains the Equal Protection Clause. It affirms equality before the law and the equal protection of the laws. Article 14 prohibits class legislation but permits classification for legislative purposes. A law does not become unconstitutional simply because it applies to one set of persons and not another. Where a law affects a classification and is challenged as being violative of this article, the law may be declared valid if it satisfies two conditions. First, the classification must be based on some intelligible differentia. Second, there must be a rational nexus between this differentia and the object sought to be achieved by the law. As a result of the ruling in cases such as Royappa versus State of Tamil Nadu, any law that is arbitrary is considered violative of Article 14 as well. This provision is significant in putting a stop to arbitrariness in the exercise of state power and also in ensuring that no citizen is subjected to any discrimination. At the same time, it preserves the state's power to legislate for a specific category of people. Article 15 disallows discrimination on the grounds of religion, caste, sex, race, etc., but permits the state to make special provisions for certain classes of persons, including women and children.